English. Now court would like to know the language you are going to use during your trial.
I guess I'm still before the same court, and I had indicated that I can communicate in English.
A1, Tandra, English, Bedr Tare, which language?
How did he came to number
2? In army, a soldier must follow his fellow soldier.
So remove from this court. Eh?
There was a change. If you gave us that, it will help us in the appeal you have directed us to. We definitely will take up the issue. But there is also one issue he has mentioned. He has said that if we are not happy with the interpretation, we can go to the Constitutional Court. So I actually rise to seek to be referred to the Constitutional Court on several issues, not just on that one issue. And one of the issues is actually the jurisdiction of this court-martial. I was looking at we have looked at the Constitution of Uganda, Article 208, which sets up the Uganda People's Defense Force, and Article 209. Nothing in those articles expressly or by implication gives the UPDF civil or criminal jurisdiction over civilians. And this General Court Martial was created through an amendment of the UPDF Act. And it is our belief that an act of parliament which amended the UPDF Act cannot amend the Constitution of Uganda. And that the Constitution of Uganda, the basic structure, which is about how duties are divided through the three arms of government, only the judiciary has the exclusive jurisdiction on civil and criminal matters, and that UPDF can only discipline its own members. These two gentlemen are civilians. We therefore want, among other things, the interpretation of that. We also want the interpretation of the fact that lawyer, what do we mean by lawyer of choice? And by arresting and sentencing Aaron Chisa when he is in court as an advocate, and the issue was a success beyond that bar, where now all these advocates are sitting. There's nothing else he wanted. He was saying, I will enter. Has that interfered with the right to representation of these two gentlemen? Is it an act that undermines the preparation of the defense of these gentlemen? We have several issues that we would like to refer and which we are going to draw your attention. If I may, I want to go over 2 or 3 of them and ask my colleagues to supplement. The first one I have indicated.
I thought we are responding. I think the chair need to guide.
You asked us to refer matters of interpretation to the Constitutional Court, and I am now seeking a reference to the Constitutional Court.
My Lord Chairman, what Constitutional Court petition and reference rules, and I don't think by submitting that she's seeking.
The question of jurisdiction was the first thing we dealt with when before I took even a brief, and the ruling of court is there. So we cannot again go backwards from where we started. So all issues are resolved, as I read to you, regarding advising on legal matters, I have given my advice. So I beg we proceed, Honorable Chair. Maybe Council Kwago was saying, calling you my lord, chairman. Nobody has forced you to say my lord. Even if you say honorable chairman, it's okay. But even if you say my lord, that's upon you. You cannot start challenging him that those calling you. He has not requested anybody that call me my lord. You can call him honorable chair of the court. It's okay. So I don't think even it's a question worth asking him that can he respond. There's nothing to respond there.
Mr. Chairman, just before my show.
Includes access, my access as council, accessing court. I'll be on record. I will not come back to this court if I'm parking 1 kilometer away. Access includes in parking within the premises. I think that needs to be also clarified by this court. We need a conducive environment as council that is persons. I'll not carry a box of books like I did today, a kilometer away from here, Mr. Chairman.
I'm sorry, my neighbor is killing me. He says Besigye should insist on the driving. Oh, sorry, of the panel constituting the court. I'm sorry, of the panel constituting this is the court.
It is all right, Council. Yes, the other day there was a canon here, as you have said. The problem of fuels, you can go out, another one coming. That's how we usually operate. Unless you will add on something, but that's how we operate. Then accessing the court. Council, I may answer maybe from the gate here, around this premise and inside here, but outside the premise, I mean the gate, I may not have an adequate answer for that. And you have anything?
I think, sir, what I can inform the lawyers is that this court is composed of 7 members before it can conduct business on any case of a capital nature. We have 7. There is now no case arising before this court where Major Sala was not present. So we are ready for today's session, sir.
Mr. Chairman, all members here and the members, which was done on that day. So this, our changing of position or alteration, just it is when we are proceeding. Or maybe unless you are asking that, where is Okarebo now? That's what you are asking.
That the validity of the the legality of the proceedings, where a member of the panel is not introduced because Colonel Okarebo was never introduced to the accused person. This is the point. All the accused persons, these ones in the dock and the Aaron Chisa, because he was also put in the dock here briefly. So Okarebo was never introduced to the accused person.
I think you could have forgotten, but that is the thing that is done on the first day when the accused persons or person appear in the dock. And they are asked, and they answered. They had no objection.
And maybe, sir, for Chisa, on contempt of court, you cannot say that Chisa was supposed to take a plea, you were supposed to be defended. There is nothing like that when you are in contempt of court. Contempt of court, you must understand about how the whole process works. So you cannot say that the panel was not introduced to him. Those procedures don't apply.
May I, once again...
But he finishes his sentence.
It's the guidance we are seeking for Mr. Chairman. How do we deal with this?
About the convict. The one who is sentenced, who is serving the sentence.
But he still has his functions, Mr.
So which means all of you cannot proceed.
I think it is very important.
After, but what I want to tell the defense attorney, in a manner that you conduct yourselves in a manner that is befitting you. This business of making noise, stand up, we go, we do what, that one is not going to be allowed. You do that, you are held responsible. Let us conduct ourselves the way we are supposed to conduct ourselves. We listen to each other and we proceed.
Mr. Chairman, allow me the latitude, Mr. In the panel, Mr. Chairman, it has far-reaching consequences. For instance, when the ruling which resulted in sentencing my land friend Aaron Kiza was being read, reference was made to his earlier conduct in 2024. But Colonel Okalebo was not present in 2024. However, he participated in sentencing Aaron Kiza. It has far-reaching consequences, Mr. Chairman. Indeed, something must be done. I thank you.
Chairman and
Mr.
the
Chairman,
court members.
I beg, Mr. Chairman, for your indulgence, Mr. Chairman. I thank you. Yeah. This is the very last one, Mr. Chairman. Be permitted, Mr. Chairman. Mr. Chairman, I beg for your
I
indulgence.
think, sir, two lawyers cannot speak at the same time.
I am seeking for the indulgence of the chairman.
But he has not allowed you.
It's a humble, I know, and
Now, because if we are to conduct ourselves like that, then we may not go anywhere.
Because, Mr. Chairman, we are dealing with matters of life and
Since
death.
we started, you are talking. Now let's hear from
Mr.
these
Chairman,
people also.
It all depends on the gravity of the matters you are dealing with. The sentence we are talking about here is...
He should respect the chair and quote. Two lawyers cannot speak at the same time when you are all standing. It's very unethical.
On the 7th of January, this court that we intend to amend the charge sheet. But because of some administrative matters, we could not proceed, which happened in court. So, Chairman and court members, treasury. So those are the two amendments we are seeking to amend. The person who is introduced on the charge sheet is RO 12743, Captain Dennis Ora, a male adult Ugandan, a soldier of regular forces of Uganda People's Defense Forces, and is attached to Armored Brigade. So is RO 474-3 in Ola. Is an office attached to Armored Brigade. And we are also adding there the count of treachery, which will be count 2, including the officer and the 2 accused persons. Those are the amendments we seek to have.
Jurisdiction. In fact, we stopped the application for reference to await on jurisdiction.
The court has no, it's in our view that the court has no jurisdiction on these two gentlemen, and we seek that the ruling precedes the amendment of the charges. When we then can raise full objection, because the charges, the amendment is not sought properly pursuant to the rules of procedure. Any colleague that you refer to Mr. Lukwago having argued on your jurisdiction trial. There is a ruling you've been seeking to deliver ever since we came.
From the Supreme Court?
From yourselves, from this court matter.
That's what was under the first day. Not the ruling. The issue of jurisdiction is the ruling which we have been under the impression that there is a ruling. And that ruling relates to matters that were raised the first time. It has something to do with the extraterritoriality of some of the offences and how we got here, and therefore it's private charges. So we have all along been under the impression we must have known the name that just refused to put it there. So I'm not sure that that regulation 66 allows him what he's asking to join.
Mr. Chairman, the way of defeating the defense which has already been brought to your attention through preliminary objections raised by my senior land friend, Counsel Elias Lukwago, when he objected the jurisdiction of this court. And indeed, there is a pending ruling. The other time when Senior Counsel Martha Karua came, we were not allowed to proceed with receiving that ruling, awaiting the grant of a temporary practicing certificate to Senior Counsel. Indeed, Mr. Chairman, there is a ruling pending before this court, and the prosecution is trying to, yes, if the prosecution refers to the notes they've been taking, they realize that indeed when we compare the same with ours, there is a pending ruling and they intend to preempt the ruling, Mr. Chairman. Don't allow them, they will be defeating justice. Thank you, Mr. Chairman.
Court graciously granted us 15 minutes. At that time, the business of the court before the adjournment was
when the court is closing to deliberate on its findings. We are still at the initial under this rule, 66. 66(1) doesn't help him. 66(2) certainly destroys him.
Relying on a matter of law to your application. Actually, the rules are so strict that once you charge an accused person, other than errors in name and at the stage of deliberation to make a conclusion, where the evidence may have revealed a different charge, you cannot add other accused persons. That's our reading of that particular regulation, Regulation 66, 1 and 2, and we are asking you to make a finding that they cannot amend at this stage. I want to thank the prosecutor for admitting that indeed we expect a ruling from the court on the earlier matter.
Bargere mesa.
proceeding.
Principles of civil court to be observed generally, and I read, except as otherwise expressly provided in this act, and any regulations made thereunder, the rules of evidence and procedure to be observed in the proceedings before a unit disciplinary committee or court martial shall, as far as is practicable, be the same as those observed in proceedings before the civil court. And the law on amendment of charges is very clear, even when you go in the criminal procedure system within the civil court. A charge sheet can be amended at any stage as long as it does not cause injustice to an accused. And the stage where we are still on the amending, where a plea was taken. No hearing has taken place, so it is my guidance.
By the institution, I think he's here, he's a counsel here, but I don't see his name tag. Maybe he has not been given. Okay. So that one. I listened to ruling on whether on whether to amend the charge sheet or not. This court, after listening to the application by counsel, Land Council for the state, to amend the charges against the accused persons by adding another suspect, and the objections, the amendment raised by land councils for the accused persons. The court has considered the submissions of both councils and the relevant laws relating to the amendment of charges, has deliberated on the application and pronounced itself as follows. 1, that the amendment can be made in the course of the proceedings at any stage as long as no injustice will be caused to the accused persons. 2, that the hearing of this case has not started and no injustice will be occasioned to the accused persons. 3, in the premises of this court hereby allows the application to amend the charges as prayed by the counsel for the state. So court clerk, you can take through the accused persons through the usual procedure.
Ola and Obed Lutare. The language of court is English. Each of you is going to tell court the language is going to use. I'm starting with you, Afande Besigye. Which language? English. Now court would like to know the language you are going to use during your trial.
I guess I'm still before the same court, and I had indicated that I
can communicate in English.
A1, Pandora, English, Obed Rutare, which language?
How did he came to number 2?
In army, a soldier must follow his fellow soldier.
I'm not a soldier. Sorry, move from this court. Eh? English.
Obey any of the members, you will say so. But if they put the reason why, I'm starting with you, Afande Besigye. Do you have any objection, any of the members?
I don't know who the members are. I know who they are before I raise an objection or otherwise.
This may put the issue is introducing the panel. Really, I do think that is where we are. Because he can't just say, look at them. What if you don't know someone? Requirement is actually...
We can provide the Brigadier General Robert Freeman Mugabe, Chair General Court Martial.
Charity Lihabwe, I'm a member.
Then Abdallah Wasajawaraba, member.
Warrant Officer 1, Asimu Robert Nyarari, member.
Major Sarah Sonko, member.
Lieutenant Colonel Sam Tungura, political commissar, member.
Captain Marion Akandinda, member.
Captain Nicole.
I think, sir, on our proceedings, the key issue is that the court is composed of 7 members. We have the members in reserve, they are present, and the court is duly constituted. So we go ahead on the next stage of responding to the questions.
No.
Has no objection. A1, sir. Captain Nora. Members who have introduced themselves? No. Captain Nora has no objection. Obed Rutare, do you have any objection to the members who have introduced themselves to you?
No. No.
Captain Rutare has no objection to the panel.
Request that I interact with him and guide him. Thereafter, I shall formalize the instructions, if you pleased.
On Regulation 23 of the regulations of this court martial, particularly sub-regulation 1, that before pleading to the charge, the accused may offer a plea to the jurisdiction of the court before taking a plea. The accused may raise the question of jurisdiction. Mr. Chairman, is on record. We have already raised issues to do with the territorial jurisdiction of this honorable court. And there is a ruling which is pending before this honorable court, which is not delivered. that this honorable court has got no jurisdiction to entertain matters which are alleged to have been committed in Athens, in Switzerland, in Kenya. We have raised that issue before you, and court, this honorable court martial has not pronounced itself on the matter. So it will be a violation of regulation 23 for the accused person to proceed and make a plea before the ruling is delivered.
It is pre-taking. You can say yes or no, and then we can start from there.
I think, sir,
Mr. Chairman, the rule is before pleading to the charge, the accused may offer a plea to the jurisdiction. That is the rule, and this is what I'm quoting. And oftentimes this court martial has reminded us to abide by these rules. And the judge advocate is so passionate about these regulations. I hope this time round is going to appropriate that advice of this honorable court martial, that it's within the accused's right not to take a plea until the ruling is delivered.
That the accused himself raised that objection. I'm the one talking.
Objection.
No, you can only object when I have talked.
Objection.
Can you listen and he finishes what he's talking
You have
about?
not raised anything.
You have not even heard that he's saying. Now you are, what are you objecting without even listening to what he's saying?
I can confidently tell this court and those who are present that the matter was raised and the court ruled on the matter. Registrar, can you avail the ruling that was raised objecting to jurisdiction by this court? Just to remind you, you read the ruling and when it was delivered. And we proceed.
A1 by then was retired Colonel Dr. Kiza Besigye. He objected to all the court members. A3 raised the same objection. J guided that the accused have to give reasons for the objections as regards court's panel and jurisdiction. A1 stated that it's a military court and I'm not a member of a military. I believe I should be tried by civilian court. A2 stated the same. J guided that state had to give a reply to the objection. State replied as follows. It captures the concerns on jurisdiction. And in reply, they stated as follows. That the enabling law, which is section 117, applies all the accused persons. That is A1 and A2 as then were referred to. He also proceeded as state and informed court that he did not even know the lawyers that were representing the accused persons. Then J.A. guided that court had to close for deliberation and make the ruling.
Councillor Kwago submitted that they had no opportunity